Distinguished participants, ladies and gentlemen, thank you all for taking the time to join this discussion on a very important topic, namely broadening the recognition of the jurisdiction of the International Court of Justice. As we mark this year the 75th anniversary of the inaugural sitting of the ICJ and contemplate the outstanding contribution of the Court to the development of international law and its judicial application in support of maintaining peace and security worldwide, it is even more appropriate to look into ways of encouraging a wider use of the Court's jurisdiction. Therefore, it is a great honor for me to host today's event, which follows the virtual high-level roundtable on the same topic organized by Romania on June 24 this year, and which I also had the pleasure to host. As we announced on that occasion, we intended to launch a campaign aimed at encouraging states to accept the ICJ's jurisdiction, building upon previous initiatives in this area. Today, we are starting this campaign. Beyond my position of current Minister of Foreign Affairs of Romania, I'm also a professor of international law and member of the International Law Commission, as well as a former pleading agent before the International Court of Justice. That is why, for me, it is more than natural to attach great importance to the peaceful settlement of disputes, not only from a theoretical, but also from practical perspectives. The respect for this fundamental principle also lies at the heart of Romania's foreign policy, together with the respect for the whole body of international law and the promotion of the international rule of law. This should be an integral part of the foreign policy of each and every state in the world. I firmly believe that one concrete way through which we can accomplish this is strengthening ICJ. Expanding the Court's compulsory jurisdiction through various options may consolidate the normalcy of submitting a legal dispute to the Court, even if, or especially when it is a matter of importance to the security or the international profile of the respective country. I have advanced the idea of launching a campaign for intensifying the outreach demarches by states supportive of the ICJ in favor of an enhanced use of the World Court during a visit I made 1 year ago at The Hague on November 9, 2020. Then I have exchanged views with the President and the Registrar of the Court regarding the potential means through which us, the states, could contribute to increasing the essential role that the Court has for the international community. The ICJ high officials welcomed the proposal I have advanced at that point, which is part of the strong support of Romania for the ICJ. We initiated this demarche with a group of supporting states composed of Japan, Liechtenstein, Mexico, the Netherlands, New Zealand, Norway, Poland, Spain, and Switzerland, whose contribution and involvement in this exercise is highly appreciated. Together, we have elaborated the declaration on promoting the jurisdiction of the ICJ, which will lie at the heart of the global campaign dedicated to this goal. Immediately after today's event, the text of the declaration will be circulated to all UN member states and opened for endorsement by any interested state through a note verbal submitted to the Permanent Mission of Romania to the United Nations in New York, acting as depository for this initiative on behalf of the core group. Updated information on the endorsing states will be posted on the websites of our Permanent Mission in New York and the Romanian Ministry of Foreign Affairs. Insofar as the structure and the content of the declaration are concerned, this document refers to the ICJ's important role in promoting the rule of law globally and inventories the main reasons for accepting the Court's jurisdiction, specifically its competence over any legal dispute among states, its vast expertise in dispute settlement, its efficiency and affordability as a dispute settlement mechanism, its anchoring in state consent as the basis for its contentious jurisdiction, and its contribution to the realization of the principles and purposes of the United Nations, such as the maintenance of international peace and security. Not least, it encourages states to have recourse to the ICJ and confer jurisdiction on the Court by any of the means envisaged in its statute. In addition, the declaration states the added value of declarations recognizing the jurisdiction of the Court as compulsory and the benefits of the compromissory clauses in treaties on the rationale that accepting on a predictable basis the ICJ's jurisdiction builds expectations of stability and consistency in international relations and thus serves the cause of international peace. At the same time, the declaration encourages states, where appropriate, to consider withdrawing the reservations made to to the specific dispute settlement provisions in international treaties conferring jurisdiction on the court, and to include compromissory clauses in new bilateral and multilateral treaties. On a general note, the declaration invites states to exercise great care when drafting titles of jurisdiction in order to avoid disputes over the jurisdiction of the court. Moreover, the declaration recognizes the merit of and draws on previous initiatives at the international and regional levels, such as the Handbook on Accepting the Jurisdiction of the International Court of Justice, developed by Switzerland, the Netherlands, the United Kingdom, Lithuania, Japan, and Botswana. These demarches should be seen as mutually reinforcing, given that the purpose of this initiative is to re-energize efforts dedicated to expanding the access to the ICJ's jurisdiction by putting forth a platform of political commitment to work systemically towards this goal. By endorsing this declaration, states will reaffirm their support for international law in conducting their foreign affairs and their readiness to advance legal arguments in defense of their positions before the leading international court as a means of translating into practice the principle of peaceful settlement of disputes enshrined in the UN Charter. We see the growing docket of the court covering a wide array of topics and involving states from various geographical areas of the world, together with the references to the jurisdiction of the court in numerous conventions of universal application, as indicative of the state's rising confidence in its highly quality judicial work and in its ability to prompt solutions that bring disputes to a peaceful resolution. Therefore, we hope to gather substantial support for this declaration. The more we rally around this initiative, the more we can convince states to bring their disputes to the court. A high number of endorsements could serve for other states as a springboard for action at the domestic level towards accepting the ICJ's jurisdiction. In terms of follow-up measures, Romania envisages undertaking outreach activities by the core group states within their respective regional groups and in their bilateral contacts. We also intend organizing dedicated events or using related conferences or opportunities, like the presentation of the annual report of the ICJ to the UN General Assembly, to disseminate information about this declaration and continue to persuade all states to join in. While countries exert their free will in choosing the most appropriate means of peaceful settlement of disputes in each context, I cannot underscore enough the importance of judicial adjudication mechanisms, and in particular the authoritative value of ICJ's judgments as reliable instruments bringing durable solutions based on law for any disputes between states. The court is the essential element of the international justice system, while its jurisprudence provides guidance to states in the interpretation of international norms and hence fosters dialogue and cooperation among governments. To conclude, let me reiterate the invitation included in the declaration to all interested states to join us in the efforts to further promote the ideal of universal acceptance of the jurisdiction of the court. I thank you, and I'm looking forward to the enriching discussions on this topical initiative.